the presiding judge for our court. And on my left, Judge Kyle A. Hickson from here in Knoxville, sitting in for Judge Dyer on the oral argument cases. I say that since Judge Dyer is on the original docket. Most of you probably know the rules. We have allow 20 minutes per side for arguments. If you represent the appellant and you want to reserve some time for rebuttal, let us know at the beginning any of that 20 minutes you wish to reserve. We have read the briefs in these cases. The records are here in Knoxville and will be assigned after arguments. But we are familiar with the cases insofar as we have read the briefs of both parties in each case. I think that's all the preliminary matters. Are there any other matters we need to take up before we start?
No, Your Honor.
If you'll call the first case, please.
Dwight, Randall, Walton, the State of Tennessee.
All right, good morning. Are you Mr. McMurray?
I am.
All right. Guess I could give you a chance to introduce yourself. I'm just looking at, I want to make sure I've got the right docket up here. And it looks
Judge,
like
that's
it's
quite
correct.
all right. That's quite all right. If I could reserve 5 minutes. And Your Honor, I appreciate this opportunity. I'm here on behalf of Mr. Walton, and I'm sure the court's already read the brief. There are two specific issues that I would really like to talk about. The first being the post-conviction DNA analysis request that was denied by the post-conviction court. Judge, in this case, TBI agent Proctor testified at trial that the DNA evidence that was suspected of being that of the victim was consistent with the victim's DNA. Upon obtaining an expert at post-conviction, in that expert's report, Agent Proctor then changed his testimony at the post-conviction hearing. He stated that he would have to change his testimony from that of being consistent with the victim to being inconclusive. Truth be told, that 1 in every 3 members of the jury would match the DNA profile to the same extent of that of the victim. And Judge, what we're asking for under the Post-Conviction DNA Analysis Act, we're asking for further testing of that DNA evidence. Under that act, there's 4 requirements. 1, that there's a reasonable probability exists that the defendant would not be convicted, and 2, the evidence still is in existence. 3, excuse me, I'm sorry. The testing was not done at the time.
Just to get your train of thoughts together, but in this case, the facts of this case, the victim testified?
The victim did testify in this case.
And the victim, in fact, identified the defendant?
The victim did identify the victim.
As the perpetrator in this case?
That is correct.
And there was also testimony regarding admissions the defendant made to other individuals in this case as to the penetration alleged or for which he was convicted of?
There was an additional witness in this case.
And this is notwithstanding the DNA?
I'm sorry?
This is notwithstanding the DNA evidence?
Notwithstanding the DNA evidence, but you bring up a very, very good point, is the context in which this case happened. Mr. Walton was actually married to the victim's mother. They were in the process of going through a divorce. Then years later, suddenly, his stepdaughter said, years ago, he had sexually abused me. This only came out during the process of the divorce. So I think that the trial counsel actually did a very good job of drawing some inconsistencies with the victim's testimony, some of the things that she testified when she reported this to the police. I think the DNA evidence, and I would submit to the court, the DNA evidence was the foundation to bolster these witnesses' testimony.
His confession? His confession to there was a third-party witness.
There was a third-party witness, which was his soon-to-be ex-wife's best friend. I think all of that could be, I would submit to the court, would be suspect, given the context of their romantic relationship at the time. It was a divorce, it was emotional, it was tumultuous, and they were in the process of trying to obviously separate their finances as well as their family.
But the standard that we're looking at, or the prong that you're looking at, is whether he would have been prosecuted.
Prosecuted and convicted.
And convicted.
And convicted.
And here, is there a question as to whether or not he would have been prosecuted?
Not prosecuted, no ma'am. But I do think the conviction would be in question. I think it undermines the credibility of the witnesses, this further testing. The further testing that we're asking for, the TBI does not even employ the testing that they used at this time. It was only 16 loci, and I know that that doesn't mean a lot. Loci, what is that? But those are specific DNA signals, okay? Now, the test that they use is either 26 or 28. 26 or 28. And as I stated before, 4 members of the jury would have matched the same DNA profile that they used at that time with the victim. It is not conclusive at all. It was the foundation which bolstered the credibility of the 2 witnesses that you referenced. I agree, it does. But this DNA test that we're asking for could exclude the victim. It could exclude the victim. If we find more markers that this victim does not have, that means it was not her DNA profile, was not hers.
What does that show, though? That another family member's saliva could be on the couch?
Well, Judge, that's a very good question. The testing that we're asking for could potentially determine whether or not it was saliva or touch DNA. Now, how can we do this? Because the state actually has within their possession the other cushions to the couch. So you can actually test to see if you have that fragmented DNA throughout the couch, which would mean statistically, with a statistical probability, that it was touch DNA. Saliva is particularly very rich DNA. And this test, if we increase the loci, it could exclude and give a more definite result as to how this DNA was actually on the couch, whether it was touch or saliva, and it could exclude the victim totally.
What would that do to help benefit your client, though? Because number one, wouldn't you expect to have other family members' DNA on the couch, be it touch or saliva? And also, not at issue here is the DNA testing of the semen, if I understand it correctly. That is definitively a match to your client on the place, on the couch, where the victim said it would be. How do you get out from under that?
We don't need to. We admit that is his DNA. He admits that he had sexual relations with his wife on the couch, and he admits that he engaged in sexual activity on the couch. We do not deny that. It is the presence of another DNA sample next to the semen on the same couch cushion that is at issue, that we are trying to determine who it is, how it was placed there, whether it was saliva, touch, or otherwise, and if that same sample is throughout the couch. If it is throughout the couch, that would mean to a very high degree of statistical probability that it was actually touch DNA. And Your Honor's questions are all very well, very good, the same questions that I had. But that brings me to another point. That's the ineffective assistance of counsel. advances in our society, it goes without saying, are to such a degree that I think that in every courtroom, a sole practitioner cannot rely just on reason and rhetoric anymore. It's very humbling to know that and to understand where our shortcomings are. And I think that in this case, especially this case, the failure of the trial counsel to actually obtain a DNA expert, to get a report just like I got from Catherine Cross, was ineffective assistance of counsel.
When was the trial in this case?
Judge, I'm sorry.
Would it have been April of 2014?
Yes,
So
sir.
11 years ago?
Yes, sir.
Was there any proof developed at the post-conviction hearing? I don't recall seeing this in the briefs, but was any proof developed regarding when these new advances in DNA occurred, when the TBI updated their protocols? What I'm getting at, would an expert have been able to have made that opinion 11 years ago, the same one that she made at the PC hearing?
It's a very good question, and I'm trying to recall as best I can, but Ms. Cross actually testified that at the time, I believe 18 to 20 loci was the standard testing. So we had 16 that the TBI employed. So at least 18 to 20 was the national standard testing at the time.
In 2014?
In 2014, okay. But I think all of the questions that we have and that I've tried to research really highlight the fact that the trier of fact needed those answers as well. Needed those answers to come to the conclusion that we're all seeking, which is justice and truth, and without which you have, at the very least, a misleading statement from consistent with the DNA is consistent with the victim, to now we know it's inconclusive with the victim. I think the failure to obtain that DNA expert really highlighted that fact. And Judge, I would like to just mention that 4030-3043 allows relief, and it shall be granted if additional analysis has not been previously employed. Judge, Your Honors, the additional analysis here, we are missing at least 12 loci. We still have this sample that's not contested. This is obviously being made to try to prove Mr. Walton's innocence. That's not contested. There is a reasonable probability. There's a reasonable probability. That's the only factor left outstanding. There's a reasonable probability exists that one of those 12 loci could rule out this victim in this case. And that's the heart of Mr. Walton's request, is that we actually have the opportunity to do that. And I know the trial court, the post-conviction hearing, he actually cross-examined Catherine Cross for her failure to actually obtain the sample and to do this testing. What he failed to recognize is that that's exactly what we were asking for. That was our petition for post-conviction relief. We wanted to test this. I believe that our criminal justice system is the crown jewel of the world. I really do. And I think that in situations like this, we can actually test. We can actually see how well we employ it in reality. Because we're all fallible. We all make mistakes. But we have an opportunity here to possibly correct a mistake. Or if it is conclusive, then we got it right. But this is something, obviously, I devote my life to, and I know you all do too, and it's something that I hold very dear, and I believe what haunts the halls of all the courthouses in this great state is the fear of an innocent man being convicted. And within these 12 loci could tell the tale of whether or not that actually happened.
Quick question.
Yes.
The post-conviction court obviously disagreed with your request for additional testing. And is our standard of review abuse of discretion on that, or is it de novo? I'm thinking it's abuse of discretion.
It is abuse of discretion.
All right.
And I think there is one case that could support the court's position if it sees fit to overturn the post-conviction court, and that's Powers v. State, wherein this court held that the court must presume a favorable result from the additional DNA evidence that we are requesting. So it's really in your analysis of what a reasonable probability is, the defense actually has the presumption on our favor, and it would be the state's obligation to actually overcome that presumption. Thank you.
All right, thank you, Counselor. General?
Good morning, Your Honors. May it please the Court. Johnny Saraceno on behalf of the state. Just to sort of back up for a second and give some procedural and factual history here. The Sullivan County Grand Jury indicted petitioner on 7 counts. Petitioner then proceeded to trial and received 7 convictions. A couple of those were lesser included offenses, but received 7 convictions nonetheless. On direct appeal, this court upheld the sufficiency of the evidence of all the counts except for count 3. That was a aggravated sexual battery count. And now we're here on post-conviction, of course, where petitioners raised some ineffective assistance of counsel claims and this DNA analysis claim. Regarding the facts, the victim in this case was 7 years old when petitioner began abusing her. While the victim's mother worked during the day, the petitioner forced the child victim to watch pornographic videos, and on multiple instances, the victim testified that petitioner self-stimulated while the child sat next to him and forced him to watch these videos. On other occasions, petitioner took photos of the child wearing thong underwear. Petitioner once digitally penetrated the victim's buttocks, penetrated her vaginally with his tongue, and the issue of greatest relevance here this morning, petitioner forced the victim to perform fellatio on him while they were seated on the couch. Petitioner completed this act while they were seated and afterwards attempted to clean up the aftermath, presumably with some kind of chemical cleaner. At trial, the state's DNA expert, Agent Proctor, testified that he visually confirmed that there were sperm cells on the couch at issue on the rightmost cushion. And he tested these sperm cells and they matched the defendant's DNA. Again, that hasn't been contested here. But then there was this second sample, this what we call the minor contributor in the briefing process. And it was determined at trial, Agent Proctor testified that this DNA was consistent with the victim's genetic profile. In addition, though, again, the victim testified in detail regarding the petitioner's abuse. The factual account I gave is based on the victim's testimony, and Jessica Swiney, a former friend of petitioner, as you all, I think, observed, recounted petitioner's admission to her, where he said, yes, I forced the victim to perform fellatio on me, and he said it was, quote, like a crack addiction. At the post-conviction hearing, the court heard testimony from petitioner's DNA expert, the state's DNA expert, petitioner himself, and petitioner's trial counsel. Regarding its findings of fact, it said it did not find petitioner to be credible as a witness, and the post-conviction court did not find the petitioner's expert to be credible as a witness. Ultimately, the court denied the DNA analysis claim based on factor 3, which is the factor that says will grant testing if additional testing would resolve a previously unresolved issue. And again, just to reiterate the petitioner's point here, petitioner's arguing that additional testing could exclude the victim as the minor contributor of DNA. I want to just highlight at the outset here, it's true we haven't contested whether or not these couch cushions are still available, but on factor 2, part of the question is whether it would those couch cushions would be capable of receiving additional tests and receive a meaningful result as a consequence of that additional testing. And there hasn't been any evidence to show that this is even possible, that we would gain new information.
Doesn't that end the analysis?
Your Honor, I think it certainly could resolve the analysis.
So I'm going to make sure I'm clear on what you're saying. This was not contested below?
Yes, Your Honor. That is my understanding of the record. Of course, I would yield to the record if this court would find otherwise, but that was my read of the record.
Okay.
In fact, I would argue that there is affirmative evidence showing that additional testing would not yield a meaningful result, even under new testing standards, modern testing standards. The original report, the reason why we only tested these 2 loci, which are to lean a little bit on my 8th grade biology education here. These, based on my understanding, these are 2 locations, 2 containers of genetic information that is testable. The reason only 2 were tested of the 16 that the state attempted to test is because of the degraded state of the DNA, the degraded state of the samples. That was the reason why we could only gather so much information. And again, to reiterate, there was no proof at the post-conviction hearing that modern testing would allow for a more detailed result. Continuing along the analysis, however, regarding factor 3, the idea that additional testing would would elucidate a more meaningful result, an exculpatory result. Just to reiterate, the victim testified regarding these particular acts. Petitioner's friend recounted this admission to her regarding the nature of exactly what petitioner had done and admitted expressly to fellatio. Even if petitioner were correct here, this kind of touches on 1 and 3, I think, the factors 1 and 3, that wouldn't indicate that the victim was testified incorrectly or somehow was dishonest in her testimony. That would only indicate, if this were different DNA, that there was a separate sex act on the couch involving another person. That wouldn't preclude or exclude the contentions by the victim that this act in fact occurred. Regardless, turning to Ms. Cross's testimony at the post-conviction hearing, she basically raised 4 issues. The first of which is, under the modern standards, would this DNA test be considered definitive, or would it be considered inconclusive? She also argued that the sample, if the victim's testimony were true, there would be more of the minor contributor sample. And then she basically made the same assertion regarding the cleaning process. If this were cleaned with a chemical cleaner, wouldn't we expect an equal degradation in the sample? And then finally, she talked about a control sample, using a control sample. But the state's expert responded to each of these contentions, saying, and admitted under modern testing standards, he would have to say that this was inconclusive, the test results, but not inconsistent. In other words, the evidence still doesn't contradict the victim's testimony.
Well, speak to defense counsel's position. I think what I understood him to say is that the testimony at trial bolstered the victim's testimony and the third-party witness's testimony, bolstered it almost to the point of misleading the jury to accredit their testimony. What's the state's position there? Are you going back to I understand what the law is, and I understand what the factors and the requirements are in this case, but speak to me in plain terms. in response to that?
Certainly, Your Honor. I would contend that the two witnesses that testified regarding independent occurrences. And so it is true that the DNA evidence certainly bolstered their testimony or helped corroborate the story, but these were two individuals that separately experienced two different situations. One was the act of fellatio itself, and one was an admission by the petitioner going on beyond just admitting that he committed the act, but describing sort of the experience it gave him. However, under the old standards, it was not improper for the state to argue that this was, in fact, a definitive result or that it was a result that corroborated. I believe Agent Proctor said that he testified at trial that 1 in 9 individuals could match this genetic profile. And so it wasn't hidden from the jury. They weren't told, oh, this doesn't, this is the science. You have to follow the science, and there's no other conclusion that can result. Regardless, even absent any DNA evidence, given that there were two witnesses that testified independently of one another regarding the nature of petitioner's actions, I don't think that even if the most exculpatory result were to happen as a consequence of additional testing, I don't think that would change the outcome of anything, prosecution or conviction. And so that goes to both factor one of the discretionary and mandatory DNA analysis statute. So to answer your question, Your Honor, yes, it did bolster, it did corroborate, but the accounts given by the victim, and I believe I cited case law here that says this court can rely on the victim's testimony alone for a conviction, or the jury can, and this court has upheld those convictions. But there wasn't just the victim, there was also petitioner's confession through a friend. And so I would just simply highlight the fact that the state was well within its rights to present this evidence as it did, and even though it bolstered the testimony was on its own sufficient.
General, let me ask you, just so you mentioned this, but I want to make sure I understand it completely. And I'm not a scientist at all, so bear with me as I try to articulate this. But you're saying the saliva sample is what it is, and that even under modern practices, it would not give a more precise result if it were tested today. What we're talking about is the fact that the TBI has now changed its protocol. There are different protocols nationally to where those results would be characterized differently today. Am I stating that correctly?
I believe so, Your Honor. The Agent Proctor testified at the post-conviction hearing that under the modern DNA testing standards, he would have to say that the results were inconclusive. That's to say, not definitive enough to say this is 100% absolutely the victim's sample here. But to be clear, he was unequivocal on this point. That's the evidence is still consistent with her genetic profile. So, I hope that answers your question, but the bottom line regarding this is that, yes, it's true. Under the old standard, this was perfectly acceptable. Agent Proctor was within the law by saying this is, we can say within a reasonable degree of certainty that this is the victim's genetic profile. Under modern standards, that's changed. But again, and I think you touched on this as well in your question, under prong 2 of the statute, there wasn't any, I wouldn't say that we can't find, do additional testing that might give us a more detailed result. What I'm arguing here is that there was no proof at the post-conviction hearing whether that would provide a more meaningful result. And what I cited to was the state's report regarding the DNA analysis that said because of the degraded state of the DNA, even though we've tried to test these 16 loci, these 16 locations or containers of genetic material, we were only able to get results from 2.
And you're saying there was no proof at the hearing of anyone saying, well, now, under these new standards, under these new procedures, we would actually be able to identify more loci and have a better result?
That's my understanding of the record, Your Honor. Regarding the ineffective assistance of counsel claim, that the petitioner, my friend on the other side here, has discussed. The contention here is relatively straightforward. The idea is that petitioner's trial counsel, Mr. Scott, was ineffective because he didn't procure a DNA expert for trial. Notably, in the post-conviction court's order on this point, it denied relief, and it also, regarding its findings of fact, said that petitioner's trial counsel, Mr. Scott, was a credible witness. It specifically stated that it credited his testimony. And the record supports the post-conviction court's finding that trial counsel was not deficient, and it said that petitioner had not shown or established prejudice. Sort of touching on his experience, giving a little context here, Mr. Scott, trial counsel, testified that he handled about 34 to 40 trials before petitioner's trial, that many of these involved DNA evidence, and that he had cross-examined TBI experts, DNA experts, numerous times. And he felt that he had studied the scientific literature in preparation for petitioner's trial, and in particular, his preparation for the cross-examination of the state's DNA expert. Regarding his trial performance specifically, Mr. Scott testified that he objected multiple times to the entry of DNA reports, and that he elicited helpful testimony from the state's DNA expert. He claimed, and I think reasonably so, that his cross-examination of the state's expert was effective because he got the state's expert to admit that the minor contributor's substance could have been sweat or some sort of touch DNA, not necessarily saliva. And he said, I questioned him about the fact that he couldn't determine what substances were mixed, what types of body fluids those DNAs were. And he claimed that he stated that he explained the DNA evidence to the jury in a more understandable way than the petitioner's expert witness did at the post-conviction hearing. Again, I think that's reasonable as well.
Was he cross-examined on the point that Mr. McMurray mentioned, that at the time the national standard for testing was somewhat more stringent than the TBI protocols at that time?
I would have to yield. I'd have to go look at the record again on that, Your Honor. And of course, I would yield to the record on that point. I don't think so. That is not my recollection.
Is that significant if he didn't?
I don't think so, Your Honor. Again, for one, I didn't see anything. I don't recall from the record anything that would indicate that testing 16 loci was somehow not the standard at the time. And regardless, the reason, part of the issue here is because of the degraded state. And I would guess that if they didn't test for more somehow, that might have been a product of the degraded state of the sample. Again, only 2 were capable of yielding any meaningful result, and the state's report said specifically, hey, look, this sample is degraded, it's in very poor condition, this is all we were able to gather as a result. And I think this may be helpful as well. I believe that the state's expert was cross-examined regarding the 1 in 9 statistic, that 1 in 9 individuals could match the genetic profile or the 2 loci that were found in the minor contributor sample. So perhaps not directly, but in a roundabout way, Your Honor, I think that there was testimony elicited by trial counsel regarding the quality and nature of the testing that the state performed at trial. So the bottom line is that trial counsel was not deficient because he effectively explained the DNA report that the state introduced and cross-examined the state's DNA expert, and said so that he did in a way that was understandable to a group of lay people, the jury. And I think the record bears that out. And again, the post-conviction court credited his testimony as being credible. For that reason, he wasn't deficient. I don't think there's been any real proof of prejudice on this point. And so, unless there are additional questions, Your Honors, we ask that you affirm the judgment of the post-conviction court and deny relief.
Thank you, General. Rebuttal?
Yes, sir. Thank you. If I may, Catherine, you're a little taller than me, I'm sorry. Catherine Cross's report stated unequivocally that any additional loci could exclude the victim. That was a report that we had obtained for the post-conviction report, and that is something that she actually testified to. The two loci that the state is referring to, that's a good way of putting it, and that's probably the Latin term, it's a location. There were only two loci that matched the victim. There were additional loci that we actually wanted tested, and that's what we're asking for. We're actually asking to test those additional loci. The statistical difference between the two experts was this. The TBI stated that it was 1 in 9. 1 in 9 individuals would share that loci, those two loci. According to Catherine Cross, it's 1 in 3 would share those two loci. So out of the 3 judges sitting here today, you would share those two loci that the victim had, that the TBI used to tell the jury that this was consistent with her DNA. It was a degraded sample. That is correct. That's why there are other couch cushions and that couch cushion. They only tested one portion of that couch cushion that we are asking to test. It could tie everything together in a scientific manner. Now, the issue of prejudice and would this have changed the outcome? Obviously, we all have our opinions and we can all opine upon that. But I think it goes without question. It would have been a different trial. What would have been presented would have been totally different. TBI could not have gotten on the stand and said, this is consistent with the victim's DNA. They admit that now. The defendant did not get that trial. He did not get that testimony.
But I'll ask you the question I asked the general.
Yes.
Did Ms. Cross testify that current testing would lead to more precise results given the degraded nature of this sample?
It should. She did not have access to the sample. And that's actually what we're asking this court for. It could.
She said it could.
Yes, absolutely.
Okay.
Absolutely.
Well, not having access to the sample, that's all she could say. I just wanted to know if she had said that or not.
Yes, absolutely. She said that additional loci from this sample could exclude the victim. It could exclude her as the potential source.
But, yes, but did she say that advances in the testing procedures would allow for recovery of those loci, unlike they were in 2014?
Yes, sir.
Okay.
Yes, sir. So what has happened, as I understand it, we probably needed an expert here today, but as I understand it, there are different testing mechanisms to broaden the loci. So now we have discovered different locations to obtain the DNA material within any given sample. The state is correct that this would not preclude, it would not be conclusive that this act didn't happen. But I don't think that that's what Mr. Walton has to prove here today. I think without question, it would be a different trial. In Your Honor, and may it please the court, we were just asking for the opportunity to perform that testing and to see if in fact this victim could be excluded. Thank you.
All right, thank you, Counselor. Excellent briefs and arguments. We appreciate that. And I think we understand the issues and we'll take it under advisement. Need a break. Next case, please. Oh, sorry.